I mean,
You did.
that's your opinion, yes. And
No, that's true. Let me ask you this. Did you interrupt your attorney and tell her, I'm not clean and sober because I'm using marijuana? That's yes or no. Did you tell her that? All right, court is calling 2023 CR 1642, State of Texas versus Janelle Garza. Can our parties approach and announce for the record for the state?
Hank Wilkins for the state.
Defense.
Elizabeth Russell for Janelle Garza.
Are you Janelle Garza?
Yes, Your Honor.
Counsel, you received all the discovery. Did you review it with your client?
I did, Judge.
Court will find that the state is in compliance with discovery. Ms. Garza, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Ms. Garza, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand you're charged with the offense of unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could fine you guilty and sentence you up to 2 years in the state jail facility and
Yes,
up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your
Are
Honor.
you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine to be probated. State recommends deferred adjudication. There's to be restitution, if any, to Josiah Hernandez. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, ma'am.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There isn't, Judge, but there might be an issue as to restitution. We are requesting a restitution hearing and we'd request a limited right to appeal on the restitution issue only if necessary.
There wouldn't necessarily be a right to appeal on the restitution hearing. It would be, this is the restitution amount. You all present evidence on that, and I either accept the amount as is or not, but there's no appealable issues for restitution.
Okay, Judge.
All right. I'm going to show you what's entitled, what's outside the agreement. The state is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation and 80 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection, Judge, but when given the opportunity, I would like to speak on behalf of Ms. Garza.
Okay. Ms. Garza, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge. Ms. Garza, at the time of the offense, had been a drug addict for several years. When she was arrested, it was her first felony arrest, and it scared her. It scared her enough to get clean and to get a job. Since May 10th of this year, she's been clean. She did it on her own without going to rehab because she couldn't afford to go to rehab. And she's been clean for over 6 months. She has reconciled with her mother, and she's been employed since June of this year. She is a different person than the person that committed this offense because she understood and is willing to take responsibility for exactly what happened and wants to move forward with her life. She understood a change was necessary. And I think the person that you see today is a different person than the person that committed this offense. So we would request you place her on deferred adjudication because of that for the 2-year period and just follow the state's recommendation, Judge.
And what did you do?
Like,
No, with regards to this offense.
what did I do?
Yes.
What do you mean? What did I do?
I mean, you're here for unauthorized use of a vehicle. So
Oh,
what did you do?
I took someone's vehicle without their permission.
All right, because the police report is saying, at least he's saying he was drugged after meeting a female at a bar. That's what I mean, you seem shocked. That's what's in the police report. Have you read it?
I went over it. It's just,
Yes.
I didn't read that exact part.
Oh,
that
yeah,
said
it
that he
says-
was drugged, but I understand.
So was he drugged?
No.
And then he said his debit card was taken without his permission as well.
I did not take his debit card.
Well, they found it in your purse. That's what the police report says.
Oh.
Because it says right here,
I don't
Victim-
remember them saying anything about that, and I
No.
don't remember having the debit card or anything.
it says, according to the original case number, victim had been drugged after meeting a female at the bar. Victim allowed the female to take him home in his vehicle. After waking up, he discovered his vehicle was gone with the keys, cell phones, and multicolored debit card. He found out later in the day his debit card had been used at a local gas station. The stolen vehicle, which is what we're here today, was found today, had the keys in the ignition, and had no signs of tampering in the steering column. Victim stated he never gave any consent to take or use his vehicle and wanted to process with charges. Victim gave us consent to process and search the vehicle. While searching the vehicle, victim's debit card was found inside her purse. So they're saying they found his debit card inside your purse.
Mhm.
You're saying,
No, I'm saying, I understand what you're saying. I don't recall them ever
I mean,
saying that, or them telling me that, or of them ever saying that they found a debit card in the purse. If they did,
yeah, that's what they say right here.
I understand. I just don't recall them ever telling me that personally, or them ever bringing
Well,
that up
wait a
to
second.
me.
This is what the police report says. The debit card was a multicolored debit bank card. I also found a gray camouflage bag in the trunk with some work gear and victim's work identification card. Suspect, that's you, was advised of her rights and asked why victim's debit card was in her purse. Suspect said she found it in the vehicle and thought it belonged to her friend. The bag in the trunk, she said, was already there. She said she didn't know the vehicle was stolen. So the debit card was found in your purse.
Mm.
When you're drug tested today, what are the results going to be?
I'll be clean.
All right, so we'll do a drug test today, then I'll come back with sentencing. All right, Ms. Abrams, can you do a drug test? All right, thank you. The record in 2023 CR 1642. State versus Janelle Garza. So when's the last time you used marijuana?
Yesterday.
All right, so your attorney was singing your praises about how you've gotten your life together and you did it all on your own. So why are you using marijuana?
Well, I guess I should say I got my life together. I used to use meth for 5 years.
I'm sorry, what?
I used to use meth and
Yeah.
amphetamine for 5 years. That's what I've been clean for the last 6 months.
But marijuana is illegal here in Texas. So why are you using marijuana?
It just helps me with my anxiety. That's basically it.
All right. But as a part of the program
I
and
would know-
taking responsibility,
Yes,
when
ma'am.
your attorney was singing your praises, talking about how you clean and sober, you
Yes.
know that sobriety does not mean that you're using marijuana. You should have stopped her and said, wait a minute. Let me tell you something. But you didn't. You waited till you got caught.
I mean,
You did.
that's your opinion, yes. And
No, that's true. Let me ask you this. Did you interrupt your attorney and tell her, I'm not clean and sober because I'm using marijuana? That's yes or no. Did you tell her that?
I told her that I was using marijuana, yes.
When you were before the bench.
No. But because I just feel like there's different types of sobriety. For me, the meth use was really bad. So,
Wow.
and I couldn't carry a job for the last 5 years. And in the last 6 months that I have been sober from methamphetamines, I have been able to get a job and get a car and see my daughter every day and be a mom and be present.
You're not allowed to use marijuana while you're on probation.
I understand that. And I understand that I would not be able to use it and I won't use it.
But do you understand you're not clean and sober?
Yes. And
So what do you do for a living?
I'm a nanny.
Oh, not anymore. I don't allow people on felony probation to be nannies, to be home health care providers, and especially someone who's not clean and sober. And who are you a nanny to? Is this a relative or somebody?
Yes.
Sister, cousin, who
Yes.
is it? All right. So that job is over with today. You understand?
Yes.
So how far did you go in school?
I went all the way through high school. I graduated and I went through some trade school. I had my medical assistant. I went through medical assistant school. I finished that.
And where are your children?
Right now she's at school.
And how old? Do you only have one
I
child?
only have one. She's 14.
And does she live with you?
Yes. And my mom and my grandparents and my other family.
When you say your mom, your grandparents, and other family, what is other family?
My aunt, my other aunt. There's a whole bunch of us that live at my grandma's house.
All right. This is what the court is going to do. Are there any other questions?
No, Your Honor.
All right, there's a $500 fine that will be probated. 3 years deferred adjudication. Going to do a TAP evaluation, follow recommendations. If they recommend inpatient treatment, we'll start with intensive outpatient treatment. There's going to be 90 sober meetings in 90 days. I'm going to want her tested for levels. If the marijuana levels go up, then we're going to address that.
Yes.
There is going to be the UA hotline. Regular reporting by Zoom or in person. $100 hours of community service restitution. Parenting classes. Once she completes parenting classes, 50 of those hours will be deemed to be satisfied. You're either going to get a higher level education or either you're going to complete trade school or whatever you're going to do. That's going to be required. And once that's completed, then the remaining of the community service will be deemed to be satisfied. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors.
Other than her daughter, accurate?
No unsupervised contact with minors.
With her.
I'm sorry?
I won't ever be unsupervised with her.
I'm sorry, what?
I won't ever be unsupervised with my daughter.
All right,
My mom always is there with her.
thank you.
Mhm.
And do you have any CPS history?
There was a long time ago, but they were both closed and dropped.
All right, and what was the CPS history concerning?
Due to my meth use.
Okay. I'm going to want field visits. One time per month. for 3 months. And if there are no issues, then it'll be one time every 4 months. Restitution, if any, and no contact with Josiah Hernandez and counsel. If there is restitution that's determined by probation and you think it's inappropriate, you can come back for a hearing.
Judge, I do think we're gonna need a hearing. They've submitted numbers to restitution that we believe is inappropriate.
Okay. All right. And probation, is there anything else she needs?
Your Honor, I apologize. You said restitution if any and no contact with Josiah Hernandez.
Yes. And it's Josiah.
Thank you, Judge. Nothing else, Judge.
Is there anything you need from the court to be successful?
No, Your Honor.
All right. And then if you all want, Ms. Ferguson will set it for a restitution hearing. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record in this court. Communication is key. If you want to be successful on probation, you'll need to communicate with the probation officer. If there's an issue and you feel they're not addressing it, you can always come back to the court. Do you understand?
Yes.
All right. Is there anything else?
No, Judge.
All right, just have a seat. They'll go over conditions with you. Court is calling 2021 CR 5521, State of Texas versus Honor Aguilar. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Orlando Way for the defense.
And are you Mr. Aguilar?
Yes.
All right, we have the interpreter who's been working all day here. Could you raise your right hand? Do you solemnly swear affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you could lower your hand if you'll state your name for the record.
Cesar Chavez, license number 2203.
All right, counsel, do you speak Spanish?
I do, Your Honor.
And do you speak Spanish fluently?
Yes, Your Honor.
Were you able to go over all of these documents with your client in Spanish?
I was, Your Honor.
Mr. Aguilar? All of the documents that I'm going to review with you are in English. Were those translated to you in Spanish?
Sí. Yes.
And did you understand all of the documents?
Sí.
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, did you review a document entitled True Bill of Indictment with your attorney? Did you understand it?
Sí. Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am, we are, Your Honor.
Mr. Aguilar, did you review a document with your attorney entitled Court Admonishments?
Sí. Yes.
Did you understand it and did you sign it in all the appropriate places?
Sí.
Yes.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Sí.
Yes.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and sentence you to more than you bargained for, the fact that you entered the plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sí.
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Sí.
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Sí.
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was, Your Honor.
Mr. Aguilar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Has anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí.
Yes.
Are you a U.S. citizen?
No.
No.
All right, counsel, would you like to address on the record the issue of citizenship?
Yes, Your Honor, we have spoken extensively that immigration has gotten a hold of him. There is currently an ICE hold, so he will be deported at the conclusion of this case, especially because we pled guilty to crimes involving moral turpitude.
All right, Mr. Aguilar, have the immigration consequences been explained to you?
Sí.
Yes.
Do you understand the immigration consequences of entering a plea in this cause?
Sí.
Yes.
Do you understand that you could be deported, not allowed re-entry into the United States, and the denial of naturalization?
Sí.
Yes.
Knowing that, do you wish to continue with this plea?
Sí.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney, and did you understand it?
Sí.
Yes.
According to the plea, punishment is to be assessed at 30 days in the Bexar County Jail under 1244. There are no applications. State is taking in consideration County Court Cause number 670151, and you're to forfeit the weapon in 670151. Did you understand that to be the plea?
Sí.
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it? Did you sign it in both places?
Sí.
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sí.
Yes.
Counsel, have there been any such motions?
Not at this time, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No me pongo.
No contest.
State any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
And no objections, Your Honor, for purposes of the plea.
All right, off the record for a moment. State, do you have the motion to destroy the weapon?
Your Honor, since this is a county court 6 case, I was gonna let those, the prosecutors there handle it. That's all right.
Oh, yeah, that's fine. All right, we're back on the record. Mr. Aguilar, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Sí.
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Sí.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports and lab reports, but most importantly, there'll be no live testimony? Did you understand?
Sí.
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
This is the court follows our agreement.
All right. Court will find you guilty as previously stated. The court will sentence you to 30 days in the Bexar County Jail under 1244. Give you credit for any time served. Take in consideration County Court Cause number 670151, and you're to forfeit the weapon in 670151. Is there anything else from either side with regards to sentencing?
No, Your Honor.
Nothing for the defense, Judge.
Mr. Aguilar, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Sí,
Yes.
And did you understand it?
sí,
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
sí,
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
sí.
Yes.
All right, we can go off the record. Mr. Aguilar, you're here because of your actions. If you have a drug problem, you will no longer be able to have that drug problem taken care of in the United States. So methamphetamine is not a good drug to be taken. I always tell people who will sell you drugs, they're not approved by any administration. They're not approved by the FDA. Their whole job is, let me sell drugs, let me make my profit and move on to the next person. You don't want to be the person that somebody's trying to identify. You don't want your parents to have to identify you because maybe you got a bad drug or maybe you overdose. Do you understand?
Sí.
Yes.
All right, good luck to you.
Thank you, Your Honor. May we be
Gracias.
excused?
Yes, you may be excused.
Want me to run it?
Yeah, sí.
Hello.
Want me to run it?
Yes.
Yeah.
Okay, I'll take it. Okay.
I'm here for just, you know, how my sentencing ran a little long down the street.
That's okay.
Just wanted to let you know I was here.
All right, we're going to bring you back for trial, I think.
Yes, ma'am.
Oh, that's done. So if you'll come back here at 1:20, the jury is going to be lined up outside. All right.
Go from there.
All right, thank you.
Honor, may I approach?
Yes, Ms. Gay.
I was here with Kevin Young last Thursday.
Okay.
In the court, we were trying to get his work schedule expanded a little bit,
Mhm.
9 o'clock. And the court said, I'm allowing him to work. But when I talked to pretrial services, they said only to 7:30. That was in the records. And they just needed something. You said he could work to
Yes.
9 o'clock. They just need something in writing from the court. I have a
All
B
right.
page.
Yes,
Would that be good enough? Okay,
yes. If you'll fill it out and talk with the state.
okay,
Yes.
I'll do that. Thank you.
All right. Is there anybody else ready on anything? All right. All right. So to the attorneys and your clients, I'm going to have you all come back here at 1:20. All right. Jury be lined up side to people who are on bond. Do not have them congregate. Bye. Thank you so much. Do not have them congregate with the jurors who are going to be in the hallway. So someone will be going to trial at 1:30 today, but I want attorneys and your client to be back here by 1:20. The jury is going to be in the hallway at 1:15. It'll probably take them about 15 minutes to line up. Any questions? All right. Go enjoy a longer lunch break than at first anticipated. All right, and this is an application, Bashan. Court is calling 2023 CR 6161, State of Texas versus Sean Edward Griffin. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Samuel Lyles from Mr. Griffin.
And are you Mr. Griffin?
Yes, ma'am.
Counsel, you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Griffin, I'm showing you what's entitled application for deferred adjudication. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah, Your Honor, the state moves to proceed on the lesser included terroristic threat, Class B misdemeanor.
Any objections?
No objection, Your Honor.
All right, just a moment. Ms. Burns. All right, Mr. Griffin, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of terroristic threat? That's a Class B misdemeanor. The range of punishment is up to a $2,000 fine and up to 180 days in the Bear County Jail.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 180 days in the Bear County Jail and up to a $2,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Griffin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on terroristic threat. They are asking for a $0 fine. They're recommending deferred adjudication in the anger management course. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision. There be a TAP evaluation, 60 hours of community service restitution, and no contact with Kevin Chase II. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense of terroristic threat as a Class B misdemeanor, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, Your Honor. The state offers State's Exhibit 1 and its attachments.
Any objections?
No objection, Your Honor.
All right, and state, is the complainant aware of this agreement?
The complainant is not aware of this agreement specifically because we've been unable to reach the complainant over the past couple of days, but the complainant did say for us to use our discretion and handle the case as we see fit.
All right, thank you. You may continue to confer.
Yes, Your Honor.
Mr. Griffin, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, Mr. Griffin, how many children do you have?
I have 5.
All right. And are they all with the person who's in the,
No, it's 4 with her and 1 with
and what are their ages?
15, 13, 9, and 7.
Okay, that's only 4 children.
That's with
Oh, okay. And the other one, how old is that one?
6.
All right. Are you employed?
Yes, ma'am.
What do you do?
I work at IFCO warehouse.
Okay. All right. If you're drug tested today, what are the results going to be
Positive
for?
marijuana.
All right. You're going to have to stop smoking marijuana. It's not allowed while you're on probation. You understand?
Yes, ma'am.
All right. This is what the court will do. The court will sentence you to 1 year deferred adjudication. 60 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, the 60 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. I'm going to want him tested for levels. Those levels need to start going down. You understand?
Yes, ma'am.
Probation, you can just do one field visit to see how everything is. If everything is fine, you can discontinue field visits or continue them as you see fit. Proof of employment within 30 days. No employment as a home health care provider with minors. Anger management. Probation, is there anything else? Yeah, we rarely do misdemeanor cases up here, right? All right, is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Griffin,
Yes, ma'am.
here's the thing. When people have children and they were previously married and that person moves on and they marry someone else and you don't appreciate the way someone's being disciplined, in this case, the taking away of the phone and the PlayStation, just because the stepfather takes that away as punishment, your answer should have been, let me call the child's mother to see why the PlayStation and phone were taken away. I know about people who are from split households or they divorced. Usually the issues that would come up on the civil side is you have someone who's not the child's parent doing physical discipline. This wasn't even a case of somebody doing physical discipline. This was a case of somebody taking away a phone and taking away a PlayStation. And what you should have done was ask your son, why did they take away the phone? Why did they take away the PlayStation? And whether you think that the taking away of the phone or the PlayStation doesn't fit the actions that your son took, the thing is, don't rush over the house. Time when that's said, the thing is to take some deep breaths, call the mother and say, hey, my son called me. He said you all took away his phone and PlayStation. Why are you taking away the phone and PlayStation? Honestly, I don't understand why children have phones, but that's neither here nor there. We didn't have them growing up because they were not invented. If you wanted to call your parent because of discipline, you had to walk down the block and find a payphone, put your quarter in, or either you had to sneak and find a phone in the house to do it. And there were no phones in bedrooms, at least for children when I was growing up. But so that's the proper thing to do, not to go over there and get upset. You understand?
Yes, ma'am.
You're going to have to learn to co-parent. Now, if somebody's disciplining your child physically, you and her need to talk about that. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you, Judge.
All right, court is calling 2023 CR 0990, State of Texas versus Dean Villarreal. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jane Norton and Nico Levin.
All right, this is scheduled for trial today. I have read defense's motion for continuance. Motion for continuance will be denied.
Well, Judge, I mean, Jason, as you know, from the continuance and from the last setting is in Caldwell County, and he's the lead on this case.
Okay.
So he's leaving tomorrow to Philadelphia. He's one of the adjunct professors for St. Mary's. I think you're aware of that as well, Judge.
Yes.
And so he's the coach for them, and so he's not going to be available. He has a letter on file for some time now. And then Monday, obviously, not obviously, but I think he told you he'll be traveling with a colleague and a friend to the Mayo Clinic. He's in some cancer treatment.
Yes.
And so he's not available, Judge.
Yeah. No, I understand. But with regards to the mock trial that he's having in Pennsylvania.
It's not he's having it, St. Mary's.
Yeah, I know, St. Mary's, and he's supervising or coaching. I have already previously told him that the court is not going to grant him for continuance to coach a mock trial team. This is an old case. I was going to make allowances for the issue with the medical issue, but jury's out in the hallway, so motion for continuance is denied.
Well, Judge, he's not present, so I'm not sure exactly.
He needs to be here. And I told him when he was here before that he was supposed to be here.
There is an additional issue. We tried to, someone from the office tried to view the CAC video last week and was unable to because the state's copy was broken. So as we stand here right now, we have not seen the CAC video as well.
All right, so you all need to watch it.
And for the court's knowledge and for the court's edification, I have never read Mr. Viriel's files. I will be completely unprepared to try this case to the detriment of Mr. Viriel, and he is definitely wishes the court to know that he would like to exert a Sixth Amendment right to the counsel of his choice, which is Jason Goss.
All right, so Mr. Goss needs to be here. Motion for continuance is denied.
Well, just so you know, Judge, he's in Caldwell County, so he won't be here for some time because it's a specially set sentencing, just so you know.
Okay.
Way predates your son.
All right, thank you.
Okay, Judge, we'll let him know.
All right, thank you. Eric Christopher Diaz.